prevented this prosecution, he would never have been indicted for taking these documents. After a year and a half, he finally succeeded in forcing Jack Smith's appropriately reluctant hand, having left the department no choice but to bring these charges, lest the former president make a mockery of the Constitution and the rule of law. Joining us now is Professor Lawrence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. Thank you very much for joining us tonight, Professor Tribe. There is another possible mockery of the Constitution that people fear in the possible rulings by Judge Aileen Cannon in this case, since she has already shown such contempt for this investigation merely being underway when it first came into her courtroom.
That's right. And when I read the tweet by my friend Judge Ludig, I thought, such a shame that this case, at least as it now stands, is not going to be tried before a normal judge who would pay attention to the fact that on these facts, there really does appear to be no defense. She would not tolerate, if she were a normal judge, many of the bizarre arguments that former President Trump is making. The argument somehow that the Presidential Records Act, which has no bearing on these charges, somehow gave him the right to keep national security information and withhold it from the government and lie to the government about having it. But we don't have a normal judge. That's really the problem. Like Bradley Moss, I would love to give her the benefit of the doubt. But those of us who did that when she interfered without any legal basis in this very case, to the extent that the unanimous 11th Circuit, a very conservative court, not only reversed her twice, but castigated her for injecting herself in violation of the separation of powers in a way that interfered with the executive branch. Given all of that, I'm desperately worried. In fact, one of the things she said that the Court of Appeals had very little patience for was, because he was president of the United States, he deserves not only a presumption of innocence, but he deserves special deference and a different set of legal standards. So much for the idea that no one is above the law. We're not helpless in this situation. In 1980, the United States Supreme Court confronted a case in which the trial judge and the defendant and the prosecutor all wanted to exclude the press and the public. And it said, you can't do that. Whatever the rules of the individual courtroom are, there is a general right under the First and Ninth Amendments to the Constitution for the press and the public to see justice done. And that right belongs especially to the victims. Warren Burger, no liberal, wrote in that case, it belongs to the victims. And who are the victims of the stockpiling of essentially treasonous possibility on the part of the president? The victims are all of us, 300 million Americans. Very few of us can fit into that courtroom. And allowing the press to sit there and then simply report after the fact is no substitute for at least a live audio feed if this judge is not removed. But in Richmond newspapers against Virginia, the case I'm referring to, the Supreme Court said that you have to have a neutral adjudicator. You have to have public access, even if the government doesn't want it. So we don't depend on the Department of Justice here to ask, why doesn't MSNBC, why don't the networks affirmatively ask that this be covered, from beginning to end, so that we can see justice done? If she is not removed, if she is not recused, at a very minimum, in order to have public confidence that in this most important of all cases, the bias of a judge who's already indicated that bias and who was appointed by this president doesn't prevent justice from being done.
Yeah, news organizations have